Welcome to the Judicial Committee of the Privy Council, where we are today continuing the hearing of an appeal from the Court of Appeal of the Cayman Islands. The case is called Primeo Fund and Bank of Bermuda Cayman Limited. We are currently hearing submissions on behalf of the Bank of Bermuda Cayman, presented by Mr. Richard Gillis, Queen's Counsel. So I'll invite Mr. Gillis now to continue his submission.
My Lords, I'm obliged. First of all, thank you for the advance warning on the question you would like us to address. Are you content that I should do that at the end of submissions?
Yes, whenever suits you.
I'm obliged. Just one point from yesterday. My learned friend said, this is page 57 of the transcript, that nectarus technically should not be cited. Could I just point out that that's not quite correct? And if I could ask your lordships to look at the Allianz decision, which we have at MS 1123, at paragraph 94, this point was raised before Sir Nigel Tier in the Allianz case. And as one can see from the last sentence in paragraph 94, I've been informed that Lord Justice Flo's intention was that his ruling may be cited, and so counsel was entitled to refer to it. It was obviously a carefully considered decision of the now Chancellor of the Chancery Division. My Lords, with that, can I turn to what's been described as the no change issue? And for your Lordship's notes, this is dealt with by the Court of Appeal primarily at paragraph 398 and 420 to 422. So that's MS 321 and MS 327. And we would invite the court to reread those few paragraphs at the court's leisure. We deal with this in our case at paragraph 81, 89 to 98, and 122. So that's MS 861, MS 864, and MS 874. Now, as your Lordships know, the no change issue operates on the premise, which we don't accept because this is an issue partly for the second appeal, that Primeo suffered relevant loss before the date of the Herald transfer. But on that premise, Primeo say that a loss which was separate and distinct pre the Herald transfer cannot cease to be separate and distinct in consequence of that transfer. And we disagree primarily for the reasons that are given by the Court of Appeal. Just to avoid any confusion, can I start by clarifying that we accept that merely by holding or subsequently acquiring some shares in Herald, that would not bar Primeo's claim for loss in relation to any direct bill misinvestments it continued to hold. And that's the point that we make at paragraph 94 of our case, which is MS 865. And that's simply because holding one share in relation to Herald does not mean that the loss ceases to be separate and distinct, because the loss of the entirety would not be made good through restoration of the value of that share. But the reason we say that the Herald transfer brought into operation the rule, and why any alleged prior loss ceased to be separate and distinct, is because of the specific nature of the Herald transfer. Primeo did not just happen to become a shareholder in Herald. Rather, as we've sought to emphasize on various occasions in our written case. So that's in particular paragraphs 5, 7, 13.3 and 94. By the Herald transfer, Primeo transferred to Herald the very assets under management, namely the direct billness investments, the subject of Primeo's claim in Cayman. And it did so in return for an equivalent subscription value of shares in Herald. And those transferred assets then became part of the Herald AUM, in respect of which Herald now claims against the common wrongdoer. So it is that very direct linkage, to use the phrase that the Court of Appeal uses at paragraph 412, namely the transfer of the direct billness aspects in respect of which the Cayman claim is made, in return for shares in Herald, in circumstances where Herald now claims for loss suffered in respect of those assets. That's the reason why the loss ceased to be separate and distinct. Now, as I submitted yesterday, it's clear that if Herald's claim in Luxembourg against R2 succeeds, the restoration in value of Primeo's shares in Herald will be made good, and that will make good the loss claimed by Primeo in the Cayman proceedings. In Luxembourg, as I explained, Herald is making exactly the same argument as Primeo made in Cayman. So Herald says that if R2 had performed its duties to Herald post-May 2007, Herald would have withdrawn all of its investments, including the transferred direct billness investments, before the balloon went up. So just as Primeo's claim is premised on withdrawing before the balloon goes up, so too is Herald's. And just to show that that's how Primeo's claim operates, could I ask you to look at paragraph 5 of Mr. Justice Jones' first instance judgment, which we have at MS 6. And paragraph 5 at MS 6, Primeo's causation hypothesis is that the defendants ought to have concluded that in the light of the business model, they were unable to perform their contractual duties, and having been informed Primeo of their concerns about billness and the reasons for not being able to perform their obligations, Primeo would have withdrawn the assets and reinvested elsewhere, thereby avoiding the eventual loss of its investments. And that was the causation and damage hypothesis being advanced by Primeo, even in respect of the 6th relevant redemption date, which you saw was 1st of November 2008. And could I show you that Herald's claim operates in exactly the same way? So if I could ask your lordships to turn to MS 159. And this is paragraph 299 of Mr. Justice Jones's judgment. Having now heard all the evidence, it has become clear that the factual circumstances relating to the claim of Herald and Alpha, the company claims, are practically the same as those relating to Herald, as to Primeo. And then at paragraph 300, it says in the first line, for these reasons, the merits of Primeo's claim and the claims of Herald and Alpha are comparable, but it cannot be said that they are identical. And then jumping down to the last two lines on that page, in my view, it can be said that the claims of Herald and Alpha have realistic prospects for success. Their claims are certainly no less meritorious than Primeo's claim. So the claims are operating in the same way. And I should also just point out that in submissions yesterday, my learned friend accepted, and we see this at day 25 and 27, that their claim was on the basis that they would have been able to withdraw. And finally, I should just point out that it was Primeo's Luxembourg law evidence that Herald had a claim which had at least a realistic prospects of success in recovering monies that would have included all the claims made by Primeo in the Cayman proceedings in respect of the direct bonus investments. So it's because of that paralleling between the claims that we say that SICA was right to conclude, the Court of Appeal was right to conclude that any alleged loss incurred prior to May 2007 ceased to be separate and distinct from the date of the Herald transfer, because from the date of that transfer, the direct bonus investment claims in Cayman would be made good by restoring value to Primeo's shares in Herald that were received under the Herald transfer. So that's the essence of the point that we make. And in our written submissions, we've set out in various places more detail regarding the Herald transfer. I don't think that any of the detail impinges upon the essence of the argument, but just for your lordship's notes, can I give you where detail is to be found? In our case at paragraph 24, MS 847, we deal with the reasons for the transfer. In terms of the mechanism of the Herald transfer, we deal with that in our case at paragraphs 25 to 28. In terms of Herald's claim in Luxembourg, we deal with that in our case at paragraphs 6 and 30. In terms of the make good points that I've just been making, we deal with that at paragraph 90 and 97. And in terms of Primeo's Cayman claim, competing with Herald's Luxembourg claim, we deal with that at paragraph 101. We would also invite the court, if we may, at its leisure, to read what has been said about the Herald transfer in the proceedings between Primeo and Herald. So that's the line of case that went up to the Privy Council. So again, if I could just give the court those references. Primeo's skeleton argument in the Pearson proceedings, that's MS 627, at paragraphs 82 to 86. Mr. Justice Jones' decision at first instance in Pearson at MS 1491, particularly at paragraphs 26 to 35. The second Pearson decision, which starts at MS 1507 in particular paragraphs 14 to 17, the Privy Council's decision in Pearson, which starts at MS 1550, and in particular paragraphs 10, 20, and 57. So on the facts that I've outlined in relation to the Herald transfer, we say that not only are the requirements for the application of the rule satisfied, but we also say that the rationale for barring such claims as explained in Marex applies. In terms of the requirements, as I've submitted, what is necessary is that Primeo should be a shareholder in Herald at the time the claim was brought. That's the reference point. So we're looking at 2013, not pre-May 2007, as my learned friend suggests. Secondly, Primeo's claim is made in respect of a loss which it suffered in its capacity as a shareholder, namely through diminution in value of shares, because that loss will be made good through restoration of value to Primeo's Herald shares, should Herald's claim against the common wrongdoer succeed. In terms of the rationale of the rule as explained in Marex, well, Primeo was a shareholder in Herald at the time it brought its claim. In consequence, Primeo was bound by the rule in Foss and Harbottle, because as my Lord Reed explains in Marex at paragraph 51, there then existed between Primeo and Herald, quote, the unique position in which a shareholder stands in relation to his company. And that's reflected in the rule in Foss and Harbottle. By becoming a shareholder, again, as my Lord Reed explains at Marex paragraphs 34 through to 37, Primeo accepted majority decision-making. Primeo, quote, entrusted the company with the right to decide how its investment is to be protected, close quote, and Primeo accepted that its investments, quote, follow the fortunes of the company. And that's Marex paragraph 35. So on becoming a shareholder, there then existed, quote, the unity of economic interests, close quote, between Primeo and Herald that Marex recognizes at paragraph 37 underlies the rule in Prudential. If Primeo was dissatisfied with that majority decision-making process in relation to how the Herald claim was being pursued, Primeo had the usual rights of a shareholder, which Marex recognizes counterbalances the fact that the shareholder has entrusted the company with how the investment is to be protected. So Primeo, as a shareholder in Herald, if it didn't like how the Herald action was being prosecuted, it has its rights as the 31%, the largest shareholder in Herald. And if inappropriate decisions were being made, it had derivative actions, unfair prejudice petitions, and statutory rights in liquidation. So As a shareholder in Herald, Primeo took the advantages of investing through a limited liability company, but in consequence was also required to accept the disadvantages. And we looked at that yesterday by reference to Lord Hodges' speech at paragraphs 103 to 107. If you regard the rule in Prudential as being one of the disadvantages of incorporation, they're bound by that because they took the advantages of incorporation. And finally, in terms of the rationale, allowing Primeo's personal recovery claim in Cayman to proceed would subvert the rule in Foss and Harbottle. And that's because the claim would compete with Herald's claim and challenge Herald's autonomy over its own claim. And my lords, if I can just take you back to Marek's paragraph 37. So that is at MS 1018. At paragraph 37, my Lord Reed, I'm sure the court remembers it, the existence of concurrent claims could also result in the shareholder preventing the company's management from dealing with its claim, in the way they consider appropriate in the best interests of the company. So that's paragraph 37. Paragraph 48, we've looked at already, that's at page 1021. And having quoted Lord Bingham, the aims identified in the first sentence respecting the principle of company economy, ensuring that the company's creditors are not prejudiced by the action of individual shareholders, and ensuring that a party does not recover compensation for loss which another party has suffered, are all objectives or consequences of the rule in Foss and Harbottle. And then paragraph 59, MS 1024, the second policy consideration was that it would be difficult for a liquidator to settle claims against wrongdoers for the benefit of the company's creditor if the wrongdoers remained exposed to further claims brought by the shareholders. The conduct of the company's claim would effectively be taken out of the liquidator's hands. This point is addressed by the rule in Prudential. And just to digress very quickly, in our submission, it's worth reflecting back to the situation in Prudential itself. Because as the court will recall, the company, Newman, opposed the bringing of the action. Newman, the company, was then under the control of independent directors, and they didn't want the claim to proceed. And your lordships will recall that their counsel was saying that they were concerned that the claim was killing the company with kindness. But what their counsel said is that Newman felt that there was nothing they could do about it because Prudential was asserting its own cause of action. And the point that is made in Prudential is that that's wrong. In circumstances where all the shareholder is claiming is a loss which is not separate and distinct, it lies in the company's own hands to have that claim barred so it retains control over its own enterprise. And in our submission, it is just important to reflect back to Prudential when one is talking about what is this concept of protection. So, my lord, can I now turn to Primeo's written case just to see what Primeo say on the Court of Appeal's reasoning on this no change point. And Primeo's only written comments on the no change point are at paragraphs 59.5 of its written case. So that's MS 822. And we respond to that in our case at paragraph 122 at page MS 874. And the first point made by Primeo, and we see this at paragraph 59(5)(a) and B, they say that the Court of Appeal had already held that the Herald transfer did not nullify the loss Herald suffered each time its cash was remitted to Bilmes. So they're trying to suggest that there's a contradiction between the finding that the loss ceased to be separate and distinct with the Court of Appeal's finding that the loss had not been nullified. But with respect, the question for the purpose of the rule is not whether the loss was nullified, but whether it ceased to be separate and distinct. So the Supreme Court decision in Marex makes clear that in a reflective loss situation, a shareholder can properly be said to have suffered a real loss. So as my Lord Reid at paragraph 28 observed, quote, "It is unrealistic to assert as a matter of fact that a shareholder does not suffer any loss," close quote. In that same paragraph, however, my Lord went on to explain why a diminution in share value is nonetheless irrecoverable. And that's because, again, reading from paragraph 28, the fall in share value or in distribution is not a loss which the law recognizes as being separate and distinct from the loss sustained by the company. It's for that reason that it does not give rise to an independent claim on the part of the shareholder. So it's not a question of nullification, it's a question of whether the loss ceases to be separate and distinct, or using Lord Sale's preferred terminology, different. And that is answered by posing the question, will the loss be made good through restoration of value in the shares? So, my Lord, in respect of the first point Primeo made, we say there's no illogicality in the Court of Appeal's reasoning. The second point that Primeo make at paragraph 59(5)(a) and C of its case, so that's MS 827, is that there's no legal principle, they say, which means that the Herald transfer changed the nature of the loss Primeo suffered so that it ceased to be separate and distinct. Well, again, as we explain in our case, that's wrong. The relevant legal principle is simply the prudential rule itself. It's because of the Herald transfer that the loss ceased to be separate and distinct. And that's the basis that the Court of Appeal identified and applied. Primeo's third point, which we see at 59(5)(d), is that because of the Herald transfer, Primeo will be required to give credit for any recoveries made, such that there is no risk of double recovery. Again, however, we say that misses the point, because the Supreme Court decision makes clear that the rule in prudential is not founded on the risk of double recovery. That's Marex at paragraph 33. So to state that the risk does not arise proves nothing. As the court held, the rule is based on the unique position in which the shareholder stands in relation to the company. The follow the fortunes principle we've been looking at, the need to ensure that the company retains control over its own assets, over its own claims. And in our submission, it's striking that my learned friend's written submissions or oral submissions do nothing in terms of trying to address that. The question that the fact that Primeo's Cayman claim competes with Herald's claim in Luxembourg and takes out of Herald's hands control over its own claim. So, my lords, in reality, what Primeo seek to do is to say that the no change issue doesn't arise. And they say that because they say you look at the applicability of the reflective loss rule by reference to the facts and circumstances when the loss first occurred. And so by that route, they seek to suggest that the question never arises as to whether the loss ceases to be separate and distinct. I've explained why we say that is wrong. And if that is not the correct starting point, once one does actually take into account the Herald transfer, we suggest that the reasoning of the Court of Appeal as to why the loss ceases to be separate and distinct is legally sound and compelling. So, my lords, those are the three key issues which we say arise in the context of the timing issue: the reference point, the capacity issue, and the no change issue. I was now going to move on to the R1 alpha point.
Just before you do, Mr. Gillis, can I just mention that you've been referring us to passages in the transcript of yesterday's proceedings. We don't actually have that yet, but no doubt we will be receiving it.
We will follow up on that immediately, and it's inexcusable. Council will get it by 6 o'clock in the evening, and so too should the court. My lords, turning to the R1 alpha point, which is the common wrongdoer point. And again, for your lordship's notes, this is dealt with in the plaintiff's written case at paragraph 64 to 70. That's MS 830. And in the respondent's case at 132 to 150, which is MS 877. And can I just start by establishing the relationship and the overlap between the R1 and the alpha points? Starting with the R1 argument, the consequence of the R1 argument is that Primeo say that none of its pre-May 2007 administration claims against R1 are barred by the rule. Now, 2 points to emphasize out of that. Firstly, as we see, as we have brought out at paragraph 9 of our case, which is MS 842, Primeo seem to accept that all its post-May 2007 losses are barred by reflective loss. And that reflects the emphasis one sees throughout Primeo's case, that it's important to understand they're talking about pre-May 2007 losses. So that's the first point. The second point is that the R1 argument only bites in respect of administration claims. But in relation to pre-May 2000 administration claims, Primeo says that it's entitled to claim both in relation to pre-May 2007 monies that were invested in Alpha and the direct bonus investments subsequently invested in Herald. So that's the R1 argument. The consequence of the Alpha argument is that Primeo says it would be entitled to pursue both its administration claims and its custody claims against R1 and R2, but that would only be in respect of money invested with Alpha pre-May 2007. So the Alpha argument, as an argument in itself, extends to both administration and custody. But at this point, it's important to remember that Primeo accepts that it has no custody claim against R2 as regards its Alpha investments. So that is what Primeo record at paragraph 16.2 of its written case. That's MS 802. So if one was thinking of it in terms of a Venn diagram, the Alpha argument is a subset of the R1 argument. The R1 argument applies to all Primeo's pre-May 2007 administration claims, whether related to monies invested in Alpha or subsequently through Herald. The Alpha argument only extends to pre-May 2007 monies invested in Alpha and only applies as regards R1. So in short, the Alpha argument is of no relevance unless the R1 argument fails. And even in that situation, and it's an argument that comes in its own right, it's only as regards the small amount of money invested through Alpha. And I think my learned friend accepted in his submissions that the Alpha point in financial terms was far less significant because only a very small proportion of monies was invested through Alpha. So, my lords, the overlap, the relationship between the two arguments is, in my submission, not that easy, but at the end of the day, that's how the two arguments relate and overlap. In terms of what drives the argument, can I just turn to that? The R1 argument relies on the fact that R2 was not Primeo's contractual administrator. From 1996 onwards, Primeo's administration contract was with R1. R2 only performed those administration functions as R1's delegatee. And even though R2 was Herald's contractual administrator, Primeo say that the rule is not engaged because there was no common wrongdoer. So that, in essence, is the R1 argument. The alpha argument adopts that argument, but adds another one, and it says that R2 was not alpha's contractual administrator or custodian. It only performed those functions as sub-administrator and sub-custodian, and for that further reason, Primeo say the common wrongdoer requirement is not satisfied. So, both arguments are directed towards the common wrongdoer requirement of the rule, and they are both founded on the same basic assertion, namely that the common wrongdoer requirement can only be satisfied where both the company and the shareholder have direct claims against the wrongdoer, in this case by contract. So, in essence, what Primeo are saying is that the imposition of another company in that contractual chain, even where there will be a right to pass on the resulting claim, means that the common wrongdoer requirement is not satisfied and the rule doesn't apply. So that's the nub of the argument. So with that, can I now start with the R1 administration claim? And we say the R1 administration claim is barred because the same wrongdoer requirements are satisfied through R2. And we say that for two reasons. First, R2 in fact performed the administration functions of all three funds. It was essentially the same administration failings by R2's employees in Luxembourg, which triggered the administration claims of each of Primeo, Herald, and Alpha. So functionally, the relevant wrongs were all committed by R2. That's the first point. The second point is that the administration claim, which Primeo has against R1, because of R2's administration failings, gives rise to a claim by R1 against R2, which would compete with Herald's and Alpha's administration claims against R2 in Luxembourg. So it's the combination of those two features. First, that R2 actually performed all the administration functions. And secondly, because there's the pass-through claims, which I'll come to in a moment, we say that the Court of Appeal was correct to hold that the same wrongdoing requirements of the rule was fulfilled, both in terms of substance, economic form, and legal liability. The necessary symmetry existed. So can I now start by saying a little bit more about the facts? and we set them out at paragraph 132 of our case, which is MS 877. So as your lordships know, from 1993 to 1996, R2, the Luxembourg company, acted as Primeo's administrator and custodian. So in those initial years, there was complete symmetry in Primeo and Herald's administration and custody agreement. Such at that stage, Primeo would presumably accept that the common wrongdoer requirement was fulfilled. And as I've said, it was the same R2 employees sitting in Luxembourg who performed Primeo's and Herald's administration. Now, as your lordships will have seen, in 1996 there was a change in the contractual structure regarding Primeo's administration agreements. Instead of Primeo contracting directly with R2, the Cayman company, R1 was inserted in the contractual chain as Primeo's administrator, and then R1 delegated the performance of those administration functions to R2. Now, as your lordships will have seen from Mr. Justice Jones's judgment at paragraphs 47 to 50, that's MS 28, this was in order to comply with a new Irish listing requirement ahead of the proposed listing of a new fund in Ireland called Select. Now, ironically, Primeo didn't go ahead with the listing in Ireland of Select, and they didn't do so because they would have had to they would have been required to disclose Madoff's identity. So they never went ahead with that listing. So in fact, the contractual rearrangement was entirely unnecessary, as it turned out. Nevertheless, the contractual rearrangement did go ahead, but functionally, nothing changed. From 1998 to 2008, it was R2's employees in Luxembourg who performed the administration of Primeo and Herald. And it was essentially the same administration failings, for example, failure to undertake tripartite reconciliation and reliance on custodian custody confirms, that gave rise to Primeo's administration claim and Herald's administration claim. And the parallelism, or the mirroring of the two claims, was a point that was made very forcefully, if I may say so, by the learned judge at first instance at paragraph 295 of his judgment. And if I could ask you to look at that, which we have at MS 157. Where the learned judge said, the factual circumstances giving rise to Herald's claim and Alpha's claim against HSSL, that's R2, are essentially the same as those that give rise to Primeo's claim, which leads me to question whether I need to apply a merits test at all. So it was because of the failings of R2's employees in Luxembourg that Primeo and Herald were able to make exactly the same administration claim. As regards R1, the company that was inserted into the contractual chain, the Cayman company performed no administrative functions. It merely organized the registered office in Cayman and dealt with local filings. Now, some of my learned friends' submissions may inadvertently left the court with the impression that Primeo did not know that the administration functions were being carried out in Luxembourg by R2. Well, of course they did, because they knew that it was Mrs. Andrecht's team in Luxembourg, and she gave evidence at the trial, and she gave evidence that it was her team that carried out administration functions for all of the three funds. Now, in response to that, Primeo's only point, if I may say so, is that the contractual claim is against R1, and that claim would not compete against Herald's claim against R2. But in our submission, the Court of Appeal was right to conclude that the analysis does not stop there. If, as the Court of Appeal found to be the case, R2's delegated performance of R1's duty to Primeo put R1 in breach as regards Primeo, then R1 had a pass-through claim against R2 in respect of that exact same liability. And that's the point that the Court of Appeal was making at paragraph 358. So that's MS 305. So your lordships are, sorry, it's page 3, paragraph 358. Under the simultaneous agreement between R1 and R2, under which R1 delegated the performance of its administration duties to R2, R2 was not to be liable to R1 or Primeo in the absence of negligence or willful default, and R1 agreed to indemnify R2 for any loss caused by R1's performance of those duties caused, other than by negligence or willful default or breach of duty on the part of R2. The effect of that clause exonerating R2 in the absence of negligence or willful breach of duty is that, whereas in this case R2 was negligent, it would be liable to R1 for any loss caused. And my lords, if I could ask you to look very briefly at the delegation agreement which the court was there referring to. So that is MS 434. And it's clause 5.1 in the delegation agreement. So this is page 434. Bob Lux, so that's R2, shall not, in the absence of negligence or willful breach of duty on the part of Bob Lux, R2, be liable to the bank, R1, or the fund, Primeo. So it's the necessary implication of that R2 is liable to R1 if it's negligent, which is the circumstance here. So that's how the pass-through claim arises. So in our submission, there is a very direct link between R2's wrongdoing. My lords, I see Lord Hodges' picture has disappeared. I don't know if he is able to hear. Can your lordships hear me? Hello, can you?
Perhaps we can just wait a moment
Yes.
or two. He has been having some difficulty over the last day or two. He may log off and then rejoin.
Yes, indeed.
Well, I think technical problems have now been resolved and we can resume. Mr. Gillis.
My lords, so I've made the 2 points about why we say the rule applies here, because the actual functionally the wrongdoing was by R2 and there were the pass-through claims. Now, my lords, of course we accept that in paragraph 79 of Marek, Lord Reid talks of causes of action against the same wrongdoer. That is obviously a sufficient condition, and one which will be fulfilled in the typical type of case. But in our submission, it's not a necessary condition. The importance of having a cause of action against the same wrongdoer is because that is how competing claims can most typically and obviously arise. And that is the functional importance, that we would say, of the requirement. But in our submission, where it can be shown that competing claims against the same wrongdoer arise through pass-through claims, as in this case, that functional requirement is rightly viewed as fulfilled, and the case falls within the rule. And in our submission, the Court of Appeal were right to reach the conclusion that the functional requirement, or looking at it substantively, the functional requirement of the common wrongdoer was satisfied. And that is because it makes no difference to the rationale of the rule whether Primeo's administration claim competes with Herald claim against R2 because it's a direct contractual claim or because it's a pass-through claim. So putting it another way, the interposition of a passive Cayman entity between Primeo and R2 from 1996 onwards to satisfy Irish listing requirements was purely formalistic and made no difference in substance or economic reality. There would still be competing claims. And in terms of the rationale of the rule that justified that conclusion, we mentioned two in particular at paragraph 135 of our case. So that's MS 878. And if I could take those in reverse order, and just very quickly, Marek makes clear, as I've already submitted on various occasions, that the nature of the shareholder rights, acceptance of majority decision making, and the concepts of following the fortune all underlie that the function of the rule is to ensure company autonomy. And in our submission, all those factors are triggered on a case like this, where factually R2 was the common wrongdoer, and the very facts which give rise to Primeo's claim against R1 also lead to a pass-through claim against R2, which competes with Herald's claim. So, as I've said, the resultant pass-through claim interferes with Herald's control of its claim against R2 every bit as much as if it had a direct claim against R2. The other point that we make at paragraph 1352 of our case about scooping the pool and shareholders acting contrary to the company's interests, etc., they're as much engaged by a pass-through claim as a direct claim. So we say that the justification for the rule applies equally to pass-through claims as direct claims on facts like this. My Lords, before I deal with the points my learned friend has made, can I just deal with one interjection yesterday by my Lord Reed? And in the course of my learned friend's submissions, my Lord Reed commented on paragraph 424 of the Court of Appeal's judgment. So maybe I can just ask you to open that up again, MS 328. Sorry, yeah. Paragraph 424B at MS 328. And my Lord, on reading that, commented that it appeared that the Court of Appeal's reasoning was based on, quote, an idea that we criticised in Marex, namely that if you have two persons, each with a claim against a third party, and one of the persons is an insolvent company, then it is a claim to be given priority. With respect, we suggest that that's not a fair criticism of the SICA reasoning, because that is not the argument that they were making. And if your Lordship rereads paragraph 424B, the SICA is not saying that Primeo's claim should await Herald's claim because Primeo or Herald was an insolvent company. Instead, the point the Court of Appeal is making is the one that I've been making, that because R1 is a passive entity with a pass-through claim, in substance, Primeo's claim against R1 competes with the claim against R2.
It's a concern that R2 might become insolvent.
Yes, there may be that possibility. I don't know. But then,
when you talk about scooping the pool and
yes,
extracting value or funds from Herald at the expense of other shareholders and creditors, what's the scenario that's being envisaged?
well, that's just making the scooping the pool argument that lies at the heart of prudential. Namely, that if the shareholder's claim is allowed to proceed first, that may be injurious to the company's claim because there may be insufficient resources to satisfy the company's claim.
So the risk of insolvency by R2.
Yes, but it's not. It's the point is not the application of some pari passu principle that means that the company's claim has to be given priority. It's the application of the prudential reasoning that the company must be free to realize the value of its assets for the benefit of all of the company's creditors and shareholders, and that the shareholders' claim should not be allowed to scoop the pool. So that's the rationale that underlies the reasoning.
Well, Ms. Gillis, there's pretty fundamental stuff here. If Primeo is, I mean, I quite see the argument if you're considering Primeo as a creditor of R2, but if Primeo is a creditor of R1, unlike the other shareholders of Herald, why shouldn't it enforce the obligation made to it by R1? I mean, your answer is that it indirectly amounts to enforcing a claim against R2.
Exactly so, and the consequence of that would potentially be that realizations would go solely to the benefit of one shareholder, Primeo, as opposed to through realization of the company's claim for the benefit of all of Herald's shareholders and creditors.
Yeah.
So,
I mean, obviously, the point might be made that you're disregarding the separate personality of R1.
well, I'll come to that now, because that is one of the objections that is being raised by my learned friend. And we would say that we're not ignoring notions of separate corporate legal entity, but all that the Court of Appeal was doing was looking at the substance of the matter and recognizing that the consequence of Primeo's claim against R1 is the pass-through claim against R2, which then competes. And so it's not ignoring separate legal entity, it's just looking at the substance of the matter, that functionally R2 was the common wrongdoer and that there is a pass-through claim. So, my lords, let me just look very briefly at the various objections that my learned friend has made. And we deal with these at paragraph 136 to 141. And the first point is that Primeo suggests that the Court of Appeal, the application to the fact of the rule to the facts, constituted an extension that involved an ill-defined test based on potential economic effect. And it was in that context, orally, that they were making the point that it ignores separate corporate entities. In our submission, neither of those points are correct. It simply involved the Court of Appeal looking at the substance of the situation, and the substance of the situation was that the claims would compete, and there's nothing ill-defined about that, or ignoring separate corporate entities. The second point that Primeo make is that, and this is at paragraph 67.2, they suggest that the Court of Appeal's analysis is confused. It's not, and equally so, the rhetorical question that they ask is misplaced. My learned friend says, and he made this point orally, that it would be a windfall for R1. But the point is that the rule isn't applied, or wasn't applied by the Court of Appeal to protect R1 or its creditors, as Primeo implies. The rule was applied to protect Herald's autonomy and to avoid prejudice to Herald's creditors and shareholders. And that, in our submission, is fully in accordance with the rationale of the rule. Nor, we say, is there any validity in either of the other points made by Primeo at paragraph 68. First, there is no proper basis for challenging SICA's explanation of how the pass-through claims arise under the delegation agreement. That explanation is obviously right, and the factual basis on which those claims arise is equally obvious. It was R2 administration's failings which gave rise to Primeo's claim against R1, and thus R1's claim against R2. The second point that my learned friend makes there is that there's no evidence that R1 would bring a claim against R2. With respect, we say that's a bad point as well. There is no evidence to suggest R1 would not assert a claim, and R1's directors' duties would probably oblige them to bring a claim. In any event, the operation of the rule is not dependent on proof that the competing claims will be brought. As the merits tests show, it's sufficient that the claim exists and has the requisite prospects of success. So, my lords, that's what we say on the R1 point. If I can move quickly to the alpha point and deal with that fairly shortly, because it raises no new point of principle. The alpha point applies the same basic objection as deployed in relation to the R1 point, namely the absence of a direct contractual relationship. As I said, in theory, it would apply to custody and administration claims, but as Primeo accept that there is no alpha custody claim pre-May 2007, it is actually only the administration claim which is in issue. And our answer is the same. R2 was, in substance, Alpha's administrator. Alpha's administrator would have contractual pass-through claims against R2, and if Primeo were allowed to pursue its administration claim against R1, the pass-through claim R2 would have against, the pass-through claim that R1 would have against R2 would compete. So could I just start quickly by outlining the alpha custody and administration arrangements as found by the judge and as reflected on the pleadings. So the Bank of Bermuda, a Bermudian company, was appointed by Alpha to act as its administrator and custodian by agreements dated the 12th of March 2003. We have the custody agreement at MS 452. We don't have the administration agreement, but it's referred to in the delegation agreement, which we have at MS 483. Now, on the same date, the 12th of March, Bank of Bermuda, the Bermudian company, entered into two agreements with R2. The first, which is a sub-custody agreement, which is MS 475, whereby BOB delegated, that's the word it uses in clause 4A, it delegated to R2 the performance of its custody duties to Alpha. So the delegation in relation to custody was by a sub-custody agreement, and then the second delegation agreement is at MS 483, and that's whereby BOB appointed R2 to act on its behalf regarding the administration duties. Under both of those agreements, BOB would have had pass-through claims against R2 in the event that R2's failings put BOB in breach of its direct contractual obligations. And those pass-through claims operated in just the same way as the Primeo R1, R2 administration pass-through claims. In terms of how the Primeo pass-through claim works, I've already asked the court to look at paragraph 358 of the Court of Appeals judgment to show how the Primeo pass-through claim worked, and exactly the same pass-through claim would arise in respect of sub-custody under clause 8 of the sub-custody agreement, that's MS 478, and more importantly, the responsibility provision at clause 5 of the administration delegation agreement, and we have that at MS 486, and maybe I should just ask the court to look at that. So it's clause 5. This is the delegation agreement in relation to administration. Clause 5, the bank, so that's R2, shall not, in the absence of fraud, dishonesty, negligence, or willful default on the part of the bank, be liable to the registrar, that's BOB, etc. So by necessary implication, R2 is liable to BOB if there has been negligence. And in terms of how the pass-through claims work, in relation to the sub-custody agreement that's described by the Court of Appeal at paragraph 359, which is MS 306, and in relation to the administration delegation agreement, it's dealt with by the Court of Appeal at paragraph 440, which we have at MS 334. And that's where the Court of Appeal say, we have also concluded that the terms of the Alpha Administration Agreement with its Bermudan administrator and the delegation, exoneration and indemnity provisions in it, which we have referred to at 359, also mean that the agreement is substantially the same as Primeo's administration agreement with R1. So there, the Court of Appeal, we say quite rightly, is saying that a pass-through claim would arise under clause 5 of the administration agreement in exactly the same way as in relation to Primeo. We point out that the reference to paragraph 360 is wrong. It should probably be 359, but it's perfectly clear what the Court of Appeal is referring to. So, my lords, it's on that basis that we say the position is on all fours with the position discussed in relation to the R1 issue. So R2 actually performed the administration functions of Alpha. It was R2's administration failings that put BOB in breach of its direct contractual obligations to Alpha. And it was those exact same failings that gave rise to BOB's pass-through claim against R2. So in substance, R2 was the common wrongdoer, and in substance, the pass-through claims would operate in exactly the same way. And so, just as with R1, we say the imposition of a passive Cayman entity makes no difference. Here, in relation to BOB, we say the imposition of a passive Bermudan entity. I'm sorry, I think I might have misspoken. Can I just say that again? Just as in relation to R1, the imposition of a passive Cayman entity R1 makes no difference. In relation to the Alpha case, we say the imposition of a Bermudan entity, BOB, makes no difference. My lords, in terms of the objections that Primeo has made in relation to Alpha, they're exactly the same as made in relation to R1. And so I'm not going to repeat those submissions. There is just one final point that I should make just for the purposes of clarity. It was agreed on the pleadings that BOB was Alpha's custodian and administrator, and that R2 was the sub-custodian and administrator. We see that in the Court of Appeal's judgment at paragraph 360, Primeo, in a letter sent after the appeal court hearing, so we have that at MS 719, tried to argue that R2 had not been appointed as Alpha's sub-administrator, and because they said that in actual fact it was a company called Management International Bermuda that was the administrator, not BOB. And from that, they tried to argue that since there had been no delegation agreement between Management International Bermuda and R2, there could be no contractual pass-through claim. As we will have seen, the Court of Appeal refused to allow Primeo to make these after the hearing arguments. But the point that the Court of Appeal make at paragraph 425 of its judgment is that even if that was the case, so that even if Management International was the administrator, such that the delegation agreement between BOB and R2 was invalid, the same pass-through claims would still arise, but under duties of care in tort rather than contractually. And so having refused Primeo liberty to bring this after the hearing argument, paragraph 425 is essentially saying it would have made no difference anyway, because the pass-through claims would have operated in tort rather than contractually. My Lords, with that, can I then move on to the merits test argument? It raises a short but obviously important issue, not just for this case, but for all subsequent cases where the court has to consider the application of the rule. And the issue, as the court knows, is simply this. For the rule to apply, must it be shown, as Primeo submit, that the company's claim is likely to succeed on the balance of probability? That's Primeo's case at paragraph 76. Or is it sufficient, as the respondents say, that the claim has a real prospect of success? That's the respondent's case at paragraph 152. During oral submissions, my learned friend sought to formulate for the first time a new test. We see this on the transcript at page 96, that the rule should only apply where it's established that the company's claim is better, or at least as good as, the shareholder's claim. So that seemed to be a comparative test, and I'll deal with that as well. As your lordships know, Mr. Justice Jones and the Court of Appeal held that the appropriate test was the real prospects test. In Mr. Justice Jones' judgment, that's at paragraph 290 to 300. And in the Court of Appeal, that's at paragraph 427 to 441. That's MS 329. And we say that the Court of Appeal was right for the reasons which it gave, and that the reasoning is supported, indeed strengthened, by the Supreme Court's decision in Marriott. Now, my Lords, we summarise at paragraph 156 to 159 of our case, that's MS 884, the three strands of the Court of Appeal's reasoning. And if I could ask your lordships to go to MS 884. And there were three strands to the Court of Appeal's reasoning, which was based on authority, policy justifications and practical considerations. My Lord, on the question of authority, I was not proposing to say anything in relation to the authorities. We recommend to the board the conclusions of His Honour Judge Rich in Perry and Day, and suggest that his explanation of the phrase available on the facts, as used by Lord Justice Peter Gibson in Shaker and al-Badawi, is obviously right. But it's perfectly clear that there are no earlier decisions which have really focused in great detail on the applicable test. To the extent that there is authority, we rely on Perry and Day. As regards the second justification for the Court of Appeal's decision, the policy justifications, could I ask your lordships to focus on the section of the Court of Appeal's judgment that we have quoted at paragraph 158 of our skeleton argument. And there the Court of Appeal reasoned, claims with a reasonable prospect of success, particularly in complex commercial litigation, are seen to have a value which can be realised and which the company should be entitled to realise. Setting the threshold at the level for which Primeo contends would make it difficult for the company to settle such claims and would increase the risk of an individual shareholder scooping the pool at the expense of other shareholders or creditors. Now, in our submission, what the Court of Appeal says there is at the heart of its reasoning as to why the reasonable prospects of success test is obviously, we say, the right test, and it's a point which Primeo's written case and its oral submissions have wholly failed to address. And the very simple and obvious point is that a claim with reasonable prospects of success, even if it is not so strong that it can be said to be likely to succeed on the balance of probability, that claim has value. It's an asset of the company, and the company should be entitled to realise the value of that claim for the benefit of all the company's creditors and shareholders, without being vexed by the personal shareholder's claim. Yet, the company's task of realising the value of a claim with reasonable prospects of success would be made significantly harder if the merits test is set at the likely to succeed standards suggested by Primeo. Because in that situation, the personal shareholder's claim would not be barred and would compete with the company's claim. And that is the fundamental point that is made by the Court of Appeal. And with respect, Primeo simply does not address that, either in their written or their oral submissions. And in our submissions, there is nothing in Marex that weakens the force of that reasoning. On the contrary, the emphasis in Marex, the majority decision, explaining follow the fortunes and reliance on the economic unity which binds a shareholder, they all further strengthen the argument. And that is a point which I've already made, but maybe I can just go back to paragraph 59 in Marex, which we have at 1024. That's the passage which I just asked the court to look at a short while ago, and the reference to in paragraph 59, the conduct of the company's claim would effectively be taken out of the liquidator's hand. And equally so at paragraph 37 in Marex at 1018, my Lord Reed is explaining that the existence of concurrent claims could also result in the shareholder preventing the company's management from dealing with its claim in the way they consider most appropriate. All of that rationale in our submission points very strongly towards the appropriate test being a reasonable prospects of success test. Now, my learned friend's oral submissions in our submission failed to grasp with the fact that this is part of the key rationale that underlies the rule. So my learned friend's submissions proceeded on the basis that it was a question of fairness to the personal claimant. So that's why he was asking, why should the personal claimant's claim be denied when the company's claim might fail? And equally, my learned friend was trying to suggest that there was a possible asymmetry of prejudice if the court wrongly barred the personal claimant's claim. And my learned friend was suggesting that any doubts should be resolved in favour of the shareholder. But my lords, all of those arguments miss the point. The rule in prudential is not founded on the relationship between the personal claimant shareholder and the wrongdoer. It's founded on the relationship between the shareholders. It's because of the nature of the follow the fortunes enterprise that Primeo has signed up to by becoming a shareholder that the personal claimant's claim for a loss which is not separate and distinct is denied to ensure that the company's claim can be realised for the benefit of all of the shareholders. My lord, just going back to our written case at paragraph 159, which is at page 885, the third point that we make is that the Court of Appeal took into account practical considerations and pragmatism. And could I ask your lordships to look at the section that we've quoted at paragraph 159 of our case, page 8, MS 885. The merits of the company's claim would have to be determined in proceedings in which the company is generally not a party. May also be particularly difficult, whereas in these proceedings the plaintiff's claim comes before the court, etc. Now, my lord, the Court of Appeal's consideration of the practical implications of applying the likely to succeed test fully accord with the approach one sees in the Supreme Court at paragraph 38 in Marex, where the court considers the pragmatic advantages of having a clear rule. And that's a point that we develop at paragraph 185 of our case. But my lords, there is one further point I should emphasize. If the rule is to achieve if the rule in prudential is to achieve its purpose of respecting company autonomy so that the company can realize its assets as it best sees fit for the advantage of all creditors without being vexed by competing claim, the rule has to be one that is readily capable of being applied at the strikeout stage. If the rule can't be readily applied at the strikeout stage, but only at trial, the rule in prudential will have failed to achieve its purpose, because the company will then be vexed by the concurrent claim until trial. And that would largely defeat the purpose of the rule. In our submission, if the merits test is set as high as likely to succeed on the balance of probability, it will actually only be in the simplest of cases that it will be capable of being applied on a strikeout application. The likely to succeed test would effectively require a trial within a trial, possibly of the sort that cannot really be carried out until disclosure and exchange of factual and expert evidence. In short, setting the merits test at the level of likely to succeed would likely defeat a large part of the purpose of the rule. It would mean there was no effective protection of company autonomy and creditors' interests. In contrast, the real prospects of success test is one that the courts are already used to applying at the strikeout stage. My lords, with that, can I deal with the specific points raised by Primeo at paragraphs 71 to 82 of its written case and its oral submissions? We deal with them at paragraphs 168 to 172 of our case, which is MS 887. And the first point made by Primeo at paragraphs 72 to 74 of its case it is simply wrong. That's, for the record, MS 833. Primeo suggests that in the light of the Marek's decision, confining the reflective loss rule to shareholders' claims, it will be unusual for circumstances to arise where the merits of the concurrent claims differ substantially. They say that's because the relevant, quote, the relevant facts, legal principles, and governing law applicable to each claim will usually be the same. And it's a point that my learned friend made at some length in his submissions, indeed suggesting at one point that the premise of the rule that may be an assumption that the company's claim is stronger. That we see at transcript page 84. That with respect is not the case. And can I remind you of Mr. Justice Blackburn's fifth proposition, which was cited with approval by, as he then was, Lord Justice Neuberger in Gardner and Parker. And we have that at MS 1256. And MS 1256, the fifth proposition, which was approved by Lord Justice Neuberger in Gardner and Parker, provided the loss claimed by the shareholder is merely reflective of the company's loss, and provided the defendant's wrongdoer owed duties both to the company and to the shareholder, it is irrelevant that the duties so owed may be different in context. And that remains good law, because we can see from Marek's paragraph 73, MS 1028, that point in Gardner and Parker was not challenged. So there is no requirement that the company and the shareholder sue on the same or even a similar cause of action. And that's illustrated, for example, by the facts in Perry and Day, which is a shareholder case. It's not a creditor case. The shareholder claim against the wrongdoer was based on rights under a shareholder agreement. The company's claim against the wrongdoer was for rectification of a property conveyance. And we also suggest that if one looks at Lord Reid's observations at paragraph 38 of Merrick's, that also shows that Primeo's argument is incorrect. In the context of considering the advantages of a bright line rule, my lord recognised that the reflective loss rule may have to be considered in the context of a proliferation of claims, possibly in different proceedings at different times and in different jurisdictions. And my Lord Reid was clearly not contemplating that the facts, legal principle, and governing laws of the two sets of proceedings would usually be the same, as Primeo wrongly suggests. So that first point, which was at the forefront of my learned friend's argument, as it needed to be, because otherwise there are very real difficulties in applying the real prospects of success test. It's wrong. The point is just wrong. Secondly, at paragraphs 74 to 82 of its case, MS 833, Primeo make a series of arguments based around the suggested unfairness of barring the shareholder's claim when the shareholder might have a better claim than the company. We deal with that at paragraphs 170 to 172 of our written case, MS 887. It was a point my learned friend also made in oral submissions. But for present purposes and looking at the clock, it's sufficient just to make 3 points. First, this case is not a case where it can be said the shareholder's claim is stronger than the company's claim. As we've pointed out at paragraph 154 and 155 of our case, the judge, in findings upheld by the Court of Appeal, held that Primeo's and Alpha's claims were practically the same as Primeo's claim, and that Herald and Alpha's claims had realistic prospects of success. I showed you those passages this morning. Second, if the company's claim does not meet the real prospects of success test, the shareholder's claim will not be barred. But if the company's claim does meet that threshold requirement, Primeo's submission fails to address the fact that such a claim has value to the company, which must be realized for the benefit of the company. Thirdly, Primeo incorrectly seeks to portray the issue as one of fairness, as between the personal claimant and the wrongdoer. The point that I've already made is that it ignores that the Supreme Court's reasoning in Merrick's, which explains the company law rationale for the rule, shows that the rule is based on the relationship between shareholders, company autonomy, and the need to ensure the company can realize its claim for the benefit of all shareholders. In relation to the suggestion of a comparative test, that the rule should only apply where it can be shown that the company's claim is stronger than the shareholder's claim. Well, what could be a more egregious interference with company autonomy than the shareholder arguing that its claim was better than the company's claim, and so should be allowed to proceed? Why? Simply because the shareholder's claim is better than the company's claim, should the fruits of the claim go just to the personal shareholder, not to the company for the benefit of all its creditors? My learned friend at various times complained about the slow pace of the Herald Luxembourg proceedings. But Primeo is a 31% shareholder in Herald. It's the largest shareholder. If it's dissatisfied with the speed or progress in those proceedings, it should have devoted its energies to hastening those proceedings not seeking to further enrich itself to the detriment of Herald's other shareholders by pursuing its reflective loss claim in Cayman. So, my Lord, we deal with one or two other points in our case, paragraph 170 to 172, but those are the key points I should highlight. Just 2 minutes on Primeo's pre-May 2007 indirect investment claim. Just 2 points. First, as we explain in our case at paragraph 17, that's MS 845, before the Court of Appeal, Primeo accepted that those claims were barred by the rule. And if I could just ask your lordships to look at the transcript, which we have at MS 702, and it's at page 703. The right-hand column in the middle of the page, page 67. One of the other points made by the respondents is to say that Primeo in any event had shareholdings in Herald and Alpha prior to the Herald transfer in May 2007. These are the smaller shareholdings which were shown on the chronology I handed up yesterday, which vary between just over 5%, just over 3% withdrawal. We accept that any claim for the diminution in value of those shareholdings would be barred by the principle. So the point was not argued before the Court of Appeal. The Court of Appeal didn't rule on it, and in our submission, it's not open to my learned friend to now seek to pursue the point before the Privy Council. The second point, if I'm wrong on that, and we deal with this at paragraph 173 to 175 of our case, is that in actual fact, the only issues that arise in respect of the pre-May 2007 indirect investments are the R1 alpha and merits points, and they should be rejected for the reasons that I've already given. My Lord, just 2 final points, which then takes me to the pre-warned question. The first point is this. If, contrary to our submissions, Marex has changed the law in a way which means that our reflective loss defence is no longer available, we reserve the right, if we have one, to argue that the Herald transfer operated to assign the rights on which Primeo now claim to Herald. And that is the point that we make at paragraph 122.5 of our case. That's, maybe I could just ask your lordships to turn that up. That's MS 875. And that is at least in part based on the fact that in the Pearson and Primeo proceedings, Primeo itself was asserting that Herald acquired Primeo's rights to claim against HSSL. So that's quoting from Primeo's own skeleton in the Pearson proceedings. That's an issue for another day in another court if it arises. But that assignment claim only became critical if Marex changed the law in a way that our reflective loss defence, which means it changed the law in a way which means our reflective loss defence is no longer available. The second point that we would make is that if our reflective loss defence is not available, Primeo has still made no proposals or suggestions to the court as to what procedural measures should be put in place. And that, I think, takes me to the question that the court put if subject to the merits point, we conclude that Primeo's claim against R2 is barred by the rule in Prudential, should we stay the claim to await the outcome of the claims brought against R2 in Luxembourg? If I could just deal with that, if you find that the claims against R2 fall within the rule, then obviously that claim is barred. If you find the claim against R1 is not barred by the rule, we suggest that you should make no case management directions at the present time. The second appeal in October should be allowed to proceed because the administration claim only succeeded because the Court of Appeal overturned the judge on a causative finding of fact, and because the Court of Appeal allowed Primeo to bring a loss of a chance claim, even though we had already had the trial on quantum, where it was quite clear that Primeo was not putting its case on the basis of a loss of chance. Now, if during the second appeal we succeed on those points, it would mean that the administration claim fails. And so if the administration claim is not barred at the present time by the rule, the second appeal should be allowed to proceed so that the court can deal with those points along with others. And it's only if, after that hearing, if the administration claim still has legs, that the court should then consider whether case management directions for stays should be made. So, my lords, that is our response to the pre-warned question.
I think what we had in mind may have been a slightly different point. One of the elements of one of the elements of the rule in Prudential is what's been called the merit test. There has to be a claim on the part of the company here at Herald. And we're being asked whether that should be approached on the basis that the test is balance of probabilities, or the test, or likely to succeed, or the test is realistic prospect of success. And it had occurred to us that another possibility would be to see what happens in Luxembourg if the claim were to succeed, or for that matter, if it were to be settled, then the conclusion might be drawn that that's enough for the rule in Prudential to operate. But if the claim were to be dismissed by the Luxembourg court, then it might be argued that there was in reality no claim by the company, and therefore no reason for the rule in Prudential to apply. But I wonder, having heard what you've said, you may say that the outcome of the proceedings isn't actually the point. The question is whether there is a claim which has some value.
Exactly, and with respect, if the court were to adopt that approach, it would totally defeat the purpose of the rule in Prudential, because it would mean that the company's claim until trial was being vexed by the personal shareholder's claim. So just think of it in terms of Herald trying to settle its claim against R2. There would be the real possibility that that would be impossible, because even if Herald came to a settlement which it was happy with, Primeo would be saying, don't forget about us. We've got our own claim. And that's the exact point about the rule in Prudential. So staying the shareholder's claim until such time as you determine the merits of the company's claim at trial would totally defeat the purpose of the rule. My Lord, just one final point. In terms of the R1 alpha arguments, it may assist if the parties could agree a diagram, and we should have done this before, which just gives a visual representation of how the contracts operate. Because, as they say, sometimes a picture is worth 1,000 words, and I'm sure we'll be able to agree the form of that with my learned friend, and we'll submit that to the court if it would assist.
I think it might well assist. Thank you.
So, my Lord, those are my submissions.
Thank you very much, Mr. Gillis. Mr. Smith.
Thank you, my Lord. By way of reply, I'll try and deal with things in the same order. I dealt with them, and then my learned friend dealt with them. My Lord, first of all, it's common ground in light of my learned friend's submissions that for present purposes, your Lordships should proceed on the basis that the Court of Appeal's analysis of when loss was suffered by Primeo is correct. Therefore, for the purposes of this hearing, in relation to the direct investment, Primeo suffered loss on each and every occasion it transferred cash to Bill Miss. That loss was not suffered by Primeo in its capacity as a shareholder, and it didn't take the form of a diminution in value of shares or distributions from shares. And my Lords, in light of my learned friend's submissions, that doesn't appear to be disputed as the starting point in the analysis. Now, the respondent's case that the recovery of that loss is nevertheless barred, as explained by my learned friend in his submissions, essentially rests on two propositions. The first is what he's called the timing point. My Lord, in relation to that, the first point we make by way of reply is that the respondent's submission, as we would suggest, simply failed to address the fact that the prudential rule is concerned with barring the recovery of certain type of loss, specifically loss which is suffered in a particular capacity, namely the capacity of shareholder. So it's focused on the question of in what capacity was the loss suffered. Now, as a matter of logic, we would suggest the question of what capacity loss was suffered in has to be assessed by reference to the time at which the loss was actually suffered. That's the essential question. One's asking yourself, well, what capacity was the loss inflicted on the plaintiff? So ultimately, my learned friend's submissions fail to address that central point, which comes out of the nature of the rule itself. My Lord, it's also striking that if my learned friend is right, then his analysis has some very odd consequences in our submission. The first is that the prudential rule would become exceedingly easy to avoid because any shareholder wishing to sue could simply sell his shares before commencing his claim. And in our submission, it's very difficult to see how that can be right as an outcome on the basis of the analysis explained in Prudential and Marex. As explained in those cases, the logic underlying the rule is that by investing in the company, the shareholder has subjected his investment to the terms of the company's constitution. He's agreed to that as part of the bargain, and it's for the company, in accordance with its constitution, to then sue for the loss suffered to the company. In our submission, it would be wrong if the shareholder could unilaterally escape the consequences of that bargain by selling its shares and then suing. But if my learned friend's right, that's the consequence of his analysis, because he says you have to look at matters by reference to the point in time when the claim is commenced. My learned friend, I don't think, really dealt with that point. He also, in our submission, didn't deal with our limitation example, which is the situation where the company simply allows its claim to become time barred, but the shareholder has a more generous limitation period. On his approach, once the company has allowed its claim to become statute barred, then the shareholder's free at that point to bring its own claim. Again, that seems to be inconsistent with the rationale underlying the prudential rule, which is essentially that it's for the company and its own decision makers to decide whether or not to bring the company's claim. If they decide not to do so, then that's a decision which the shareholder has to live with, because that's part of the original bargain under which he made this investment. Similarly, one also asks, well, what's the position if the company actually settles its claim? I think on my learned friend's analysis, it must be right that if the company settles its claim and no longer has a claim, then the shareholder at that point is free to sue, because he says you look at matters by reference to the time when the claim is commenced. Again, it's very difficult to see how that can possibly be the position. So, my lords, we do suggest on the timing point, you have to look at the moment at which the loss is suffered and identify the capacity in which it's suffered. The second proposition, which my learned friend needs to establish, even if he was right on the timing point, is that the loss originally suffered by Primeo, not in its capacity as a shareholder, changed its nature as a result of the in-specie subscription for shares in Herald, so as then to become indistinct and irrecoverable loss. That's essentially the second point which he needs to establish. However, we suggest that can't be established either. The position is essentially this. Immediately prior to the Herald transfer, Primeo had suffered losses on its direct investments, and it could have brought claims against the respondents in respect of their breach of duties relating to such investments. It could have done that on the 30th of April 2007, say. It's no part of the respondent's current case, and I'll come back in a moment to the reservation of rights, which we just heard, but it's no part of the respondent's current case to say that those causes of action of Primeo against the respondents were transferred or assigned to Herald as part of the in-specie subscription. On the contrary, they remained with Primeo. It's common ground that Herald did not pay Primeo anything for Primeo's claims against the respondents, or that it was any part of the bargain between Primeo and Herald that Primeo's claims against the response would be transferred to Herald. It wasn't part of the consideration for the subscription that Primeo would contribute its claims which it had against the respondents. Now, in our submission, it follows from that the causes of action of Primeo against the respondents to recover its loss were not contributed to Herald. They didn't form any part of Primeo's investment in Herald. They didn't form any part of the consideration which Primeo was providing and agreeing to provide in return for the shares which it was receiving in Herald. Now, in those circumstances, it seems to us that there was no merging of Primeo's existing claims against the respondent with any assets of Herald at all. They didn't become part of Herald's assets under management, as my learned friend would put it. They remained the property of Primeo, and that has been the position at all times. Now, if that's right, and we respectfully submit it is, it's impossible, we would suggest, to see how the loss, which was originally suffered by Primeo, not in its capacity as shareholder, which it's entitled to recover, somehow changed so that those causes of action, which Primeo has retained the benefit of throughout, become valueless. Now, my lords, it also follows from this, we suggest that my learned friend's points about company autonomy and majority decision-making are misplaced. Those points obviously apply to the investment made by a shareholder in the company, since it's that investment which the shareholder is agreeing will become subject to the constitution of the company. However, as I say, in the present case, Primeo's claims against the respondents did not form any part of any investment made by Primeo into Herald. On the contrary, since they were not assigned or transferred to Herald, then it was necessarily part of the bargain between Primeo and Herald that Primeo would remain entitled to prosecute those claims itself. They weren't contributed into Herald, and therefore it wasn't any part of the bargain that those claims would be subject to the decision-making imposed by the Herald corporate structure. And one can test it this way. Let's assume that Primeo and Herald had sat down and expressly negotiated and agreed between themselves that Primeo's claims against the respondents would remain with it and wouldn't be transferred to Herald. And we submit that that is in law what happened here. But let's assume that was, they sat down and expressly agreed that between themselves. I mean, it couldn't possibly be said in those circumstances that those claims formed part of the investment which was contributed into Herald, so that they would then be subject to the decision-making of the Herald corporate structure. The whole basis of the transaction would be those claims would remain with Primeo and would remain as its property. And in our submission, that's the position here. The claims weren't transferred. They remained the property of Primeo. They didn't amount to any investment into Herald. Now, my lords, in that context, it might be helpful just to go back to one of my learned friend's examples, which he himself gave yesterday. He referred to the situation of an individual who'd carried on a business and then contributed that business to a company in return for shares in that company. Now, assume that prior to the transfer, the business had suffered loss and that there was a claim by the individual against the accountants who were responsible for the bookkeeping. That claim wasn't assigned or transferred to the company as part of the subscription for shares. Why, one asks, can't the individual still bring the claim against the accountants? He'd suffered loss. He was owed a breach of duty by the accountants. He had a cause of action. He hasn't transferred that claim to the company. It remains his property. Why is it that he can't bring a claim? Now, of course, as part of bringing the claim, he would have to give credit, whatever the value of the shares are, which he now holds in the business. But that's a separate question, which goes to the assessment of damages. It doesn't bar him from bringing the claim in the first place. And that, in our submission, is essentially the position in the present case. Now, my learned friend focused heavily on the question of whether Primeo's loss would be made good if Herald's claims succeeded. However, the question of whether loss might be made good through an alternative source isn't a sufficient condition for the application of the rule. It doesn't, in fact, form any part of the formulation of the rule set out in paragraph 79 of Marex. And the question of whether loss might be made good through an alternative source would ordinarily, as your lordships observed in Marex, be dealt with through the normal rules relating to the assessment of damages. And indeed, my learned friend accepted at the start of his submissions this morning that merely holding or acquiring shares in Herald is not sufficient to engage the rule. So the fact that Primeo holds shares in Herald, or the fact it has acquired shares in Herald, isn't on his analysis sufficient to engage the rule. And it all turns ultimately on the precise nature of the transaction, he says, by which Primeo subscribed for the shares in Herald. But certainly the idea that just because the loss might be made good through an action brought by an entity in which the claimant is a shareholder is a basis for applying the rule is, in our submission, mistaken. Now, well, just at this point, that there's just two factual points I just need to pick up on. The first is my learned friend referred to the table in the joint memorandum of the quantum experts, which illustrated the figures in relation to the net investment claim and also the withdrawal claim. Your lordships might recall that that table was constructed by reference to 6 relevant redemption dates. Just to be clear, there is no live claim to withdrawals based on relevant redemption dates post the 1st of May 2007. And the reason for that is that the claim on causation has not been upheld on causation in relation to any hypothetical withdrawal post 1st of May 2007. And you can see that in relation in the Court of Appeal's judgment, paragraphs 345 to 347, which is page 301 of the electronic bundle. So it's not right to say that there are live claims in relation to hypothetical withdrawals post May 2007. The second point on the facts is that in support of his argument that the loss would be made good, my learned friend relied on Herald's claim in Luxembourg for $5.6 billion US. And this is day one, page 107. That claim was in fact commenced after the trial in the present proceedings and only shortly before the Court of Appeal hearing, and there is no evidence at all as to the merits of that claim. So, my lord, just pulling the strands together, tellingly in our submission, my learned friend did not at any point in his submissions argue that any issues relating to double recovery, double payment, couldn't in practice be satisfactorily dealt with as part of the normal process relating to the assessment of damages. And that is a very telling point, because he was not suggesting to your lordships that these practical issues couldn't be dealt with as part of that process. And finally, my lords, on the application of the rule, just on my learned friend's cash box example, which he gave yesterday at the start of his submissions, where he gave an example of a box containing a bond which had to be redeemed by December 2008. But prior to the redemption, the claimant had become a shareholder in a company that had acquired the box. In our submission, that isn't a very good example. And the reason is that in that case, no losses suffered until the bond expires in December 2008, by which time, on his example, the claimant has become a shareholder in the company which has acquired the box. It's not the same as our case, where Primeo had suffered loss prior to the Herald transfer and prior to becoming a shareholder in Herald. So we respectfully suggest that's not a particularly illuminating example. My lords, so far as the common wrongdoer point is concerned, my learned friend is in effect inviting your lordships to expand paragraph 79 of Marek's to include what he refers to as pass-through claims. In our submission, there isn't any basis for that. He said that the second respondent was the factual wrongdoer because it was the one that was actually carrying out the work. But so far as Primeo is concerned, the wrongdoer is the first respondent. It was the first respondent that breached its duties to Primeo, and subject to the prudential rule, we are a creditor, the first respondent. Now, the question of which entity you are a creditor of may be of absolute critical importance. If the position is that the first respondent is very solvent and has very few creditors and is well capitalized, then obviously one wants to be in a position of having a claim against that entity. If, on the other hand, one's in a situation where the second respondent, say, is insolvent, one's going to be prejudiced by having one's claim against the solvent first respondent in effect excluded on the basis that the company has a claim against what is an insolvent second respondent. So the question of which entity against whom one has a claim is potentially of critical importance, and one can't sweep that away. Separate corporate entities, separate corporate identities in our submission have to be observed. Well, aside from that, we do respectfully submit that my learned friend didn't really face up to the fact that his argument does give rise what we would respectfully say is an absurdity, that the first respondent ends up facing no claims at all from any party, despite the fact it's been found to have acted grossly negligently in its duties as Primeo's administrator. Why, one asks, should the first respondent and its shareholders and creditors benefit from that windfall, so that it ends up not having a claim from anyone? I mean, in our submission, my friend didn't provide an answer to that. There isn't an answer to that point. It demonstrates why his analysis is flawed. We also suggest that, although my friend repeatedly used the phrase pass-through claim, and it's a somewhat beguiling expression, it needs to be treated with some care, and indeed it's not really an accurate expression. This isn't a situation of pass-through claims as such. The correct analysis is that Primeo has a claim against the first respondent. The first respondent may have its own claim against the second respondent, but that's the first respondent's claim. It's subject to potentially quite different legal principles. It arises under a separate agreement, and it's a question for the first respondent ultimately whether it pursues that claim or not. It might well choose not to do so. It's not a pass-through claim in the sense that the first respondent effectively sits there as a mere intermediary. My Lord, just two final points on that. The first is that we were clear, I think, that the first respondent argument does apply to all claims in respect of all indirect investments. I made that very clear on day one at page 100, lines 15 to 18. So contrary to my learned friend, this point in relation to the first respondent applies to all claims in relation to both direct and indirect investments. And the reason is that it's obviously a complete answer to the application of the rule in relation to any claim against the first respondent. So as far as the merits test is concerned, I think all I would say is that ultimately one has to strike a balance in the appropriate way. And the question is, why should a shareholder's perfectly good claim be excluded merely because the company has a claim which can be said to be realistic but ultimately fails? The effect of that is to confer a wholly unjustified windfall on the wrongdoer. And the point which we were seeking to make was that where there is a choice between the risk of conferring a windfall on a wrongdoer and having to deal with difficulties about competing claims through the usual procedural devices of the court, then the choice ought to be obvious. One should err against conferring the windfall on the wrongdoer, and to the extent there are potential difficulties concerning concurrent claims, issues of double recovery and so on, those can be managed either through the rules relating to the assessment of damages or through the procedural powers of the court. And what one shouldn't do is allow the tail to wag the dog and allow those sort of ultimately what one might describe as procedural issues which are capable of being managed as striking out a good claim by a shareholder and therefore potentially allowing a wrongdoer to escape completely scot-free. So, my Lord, that's all we were going to say by way of reply on the merits test. And that, I think, just finally brings me to the question which your Lordship sent by email last night, which concerns the question of whether there should be a stay of the claim against the second respondent to await the outcome of the claims brought against the second respondent in Luxembourg. Obviously, our primary position is that in order to rely on the prudential rule to exclude Primeo's claims, it's incumbent on the second respondent to establish that Herald has good claims which are likely to succeed. It has not done so. It has not done so at trial. And therefore, on that basis, it can't rely on the prudential rule to exclude Primeo's claims. The issue with a stay is that there is simply no evidence as to how long proceedings in Luxembourg might take. We already know that they've taken a very long period of time without appearing to have got very far. But that's obviously the practical issue. The second respondent hasn't at any time previously sought a stay, and we submit it's now too late for it to do so, having been through trial and now in effect on the second appeal on this matter. So that's our primary position, which was ultimately that the burden was on the respondents to establish that the rule applies. They haven't done so. They can't now evade the consequences of that by trying to pay an aid a stay. If you were against me on the primary position and on our other points regarding the application of the rule, including our submissions on the merits test, then as an ultimate alternative, then we would submit that the proceedings against the second respondent ought to be stayed rather than being dismissed. But as I say, that would be the ultimate fallback and would only arise if you were against me on, I think, absolutely everything else. So, my lords, unless I can assist you further, those are points we wanted to add by way of reply.
Well, thank you very much, Mr. Smith. I don't think we have any questions for you, as far as it appears. We're grateful to counsel on for both parties for the quality of the argument that we've received in this case. It's been very well argued on both sides of the argument, so thank you for that. We'll now take time to consider the submissions and decide what advice we shall humbly tender to Her Majesty. In the meantime,
thank you very much, my lords.
the court will adjourn.